Less than 24 hours after filing a motion to dismiss an appeal that could remove her from prosecuting the election interference case against former President Donald Trump and his allies, Fulton County District Attorney Fani Willis spoke about the challenges she faces in her position.
As we knew was going to happen, once we had the prosecution go and file basically a gag order saying that they didn't want attorneys out here talking about the YSL RICO trial, what was going on with the trial, what their feelings were. Miss Love said, hey, I don't want anybody over here throwing shots, talking about my attitude. Well, the defense responded, and we're going to get into it here. This is breaking news. If y'all haven't seen what I'm talking about with the extrajudicial motion, you can go back and watch that video where we pretty much break it down and explain everything that's said in here. But right here we have Doug Weinstein, aka DeMonte Kendrick's representation, aka Yak Gotti's representation. He responded to this motion that was filed by the state. What is he saying here? Kendrick's, well, we'll start it off the right way. The state of Georgia versus DeMonte Kendrick. Right, here we go. Kendrick's opposition to state's motion to restrict extrajudicial statements. Basically, they're trying to shut it down. They don't want them talking. Here's what he says. Comes now defendant Yak Gotti, we're going to call him, in the above style case in opposition to the state's motion to restrict extrajudicial statements. I'm going to get it right one of these days, y'all. Showing the court the following. Everyone is in favor of free speech. Hardly a day passes without its being extolled. I agree. But some people's idea of this is that they are free to say what they like, but if anyone says anything back, this is an outrage. Sir Winston Churchill. That's an excellent quote by Mr. Weinstein there. I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not going to target anyone. You do not get to commit crimes in my country and then get to decide to brag on it. Which you do that for a form of intimidation and to further gain and to not be held responsible. The Honorable
Stop the cap.
Fani Willis, Fulton County District Attorney, press conference, August 29th, 2022. Now, why is he quoting this? Because the top of the top of the top, which I mentioned when we were on the live stream Wednesday, when we were on the live stream Wednesday and in past videos, that this is completely hypocritical by the district attorney's office. For them to say they don't want anybody talking about it, and then you had Fani Willis, while she was involved in an active case, an active trial, an open investigation, whatever you want to call it, speaking out about it on multiple occasions, which we're going to show evidence and proof of here. This is an excellent quote and an excellent call out, because Fani Willis was going all over the place doing exactly what they're trying to stop these attorneys from doing. You can't do that. This whole thing is a bunch of BS, but hey, Mr. Weinstein is going to keep going in. Free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. Oh, man, Weinstein is letting them fly. Shout out to Yak Gotti. The state would apparently like the present trial to be conducted in secret, with proceedings happening in hidden chambers outside of the prying eyes of the press and the public. God dang. Yo, I'm going to be going crazy with the sound effects on this one, because Yak Gotti's his representation were cooking on this. This is crazy. So not only is he taking shots at Fani Willis, not only is he taking shots at Judge Glanville, who pretty much botched this entire trial from the start, but he's taking shots at the ex parte meeting that took place at ADA Love, ADA Hilton. He's burning all the bridges here. He did call Fani Willis honorable, which I'm not.
Stop the cap.
I'm not going to do that. She stole my money, so I'm not rocking with Fani right now. But let's go back. Let's keep reading. So he says, The state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of risk to the witness, despite the court's order that such a showing be demonstrated prior to blocking the broadcasting of witness testimony. Exactly right. After attacking the integrity of representative counsels of defendants and witnesses, they're referring to Brian Steele. When he went back with Judge Glanville said, hey, you're unprofessional and unprepared. And as we saw, Brian Steele had a big issue with that. And he goes into more detail here. Repeatedly calling the Honorable Brian Steele, there we go, see, it's not just me, the Honorable Brian Steele a liar, and accusing the Honorable Jonathan Melnick of working for the defendants rather than his client, Lil Woody. The state now turns its attention to counsel for DeMonte Kendrick. Mr. Weinstein is taking this personally, as he should. But to paraphrase President Truman, counsel does not give the state hell. Counsel tells the truth about them, and they think it's hell. In a 1.5 page motion, the state cites the Rule 3.6 of the Georgia Rules of Professional Conduct and cherry picks certain comments to the rule to support its motion to instruct the defense to refrain from making extrajudicial statements about the case moving forward. No case law is cited. No finely tuned order is proposed. As the state accurately quotes 3.6 bars, excuse me, 3.6 bars lawyers for making extrajudicial statements that a lawyer knows or reasonably should know have a substantial likelihood of materially prejudicing an adjunctive proceeding in the matter. The state provides no specific quotes of Kendrick's counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by Kendrick's counsel that might arguably violate Rule 3.6. Oh man, Weinstein is cooking. And we're going to get to 3.6 here in a second, but I've got some other things I want to show y'all. The court should decline this invitation. Remarkably, the state does not make a single argument that any statement by Kendrick's counsel meet any of the elements of Rule 3.6. Instead, the state simply offers up a single conclusionary statement. There is no argument that any statement made by which is being streamed daily to the public. To the extent there are any remarks not specifically in the public record, such statements are general remarks indeed to demonstrate that Kendrick should not be on trial. And I mentioned this too. I didn't have a problem with them talking about the case. What I had an issue with was the risk of them saying that something that's not known to the public, or something that's attorney-client privilege. And I just said it was risky and I didn't think it was worth the risk. And that's basically what Mr. Weinstein said here. He said, yeah, maybe we were talking about the trial, but we weren't talking about anything that no one else knows, which is totally allowed by 3.6. Justice Kennedy rightfully understood the present situation that Kendrick and his counsel find themselves in. Kennedy wrote that an attorney's duties do not begin inside the courtroom. He or she cannot ignore the particular implications of a legal proceeding for the client. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives, which we have seen over and over. I mean, they got Judge Glanville out of there because, as Brian Steele said, he was on their team. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. Okay. And then he cites a few more things. We're not going to go through all that. But he says this is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Kendrick is allowed to take reasonable steps to protect his reputation, and those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him, initially by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and injustices around him. And now by holding press conferences denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. Wow, I'm so glad he brought up the court of public opinion, because we've mentioned it several times here. We're all able to see everything that's going on. We're able to see Glanville. We're able to see Brian Still. We're able to hear the witnesses and see Lil Woody on the stand have an attitude with Miss Love up there. So we're able to see all this. The court of public opinion is very involved. And moving forward, that's something that you're going to have to factor in as well, and something that even factored in to Judge Glanville being removed. So that's a great point by him. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Wherefore, Kendrick prays that the court deny the state's motion. Respectfully submitted, Doug S. Weinstein. Give it up. Give it up to Mr. Weinstein. That man went in on this one. This is probably going to be one of my favorite motions so far, because he did not hold back, and he even pointed to ADA Love and ADA Hilton's boss to say, your boss was out here talking when she shouldn't have been, which we're going to get into actually in a second. I want to go to 3.6 in case y'all hadn't seen this yet. And sorry, it's not centered on the screen. Let me get this for y'all so I can center it on the screen. There we go. All right. Rule 3.6, trial publicity. We're going to go through it real quick. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing and proceedings in the matter. All right. Notwithstanding paragraph, a lawyer may state the claim, offense, and defense involved and expected when prohibited by law, the identity of the persons involved, information containing in public record, which they're talking about. Everything they're talking about in these interviews is public record. And we've actually seen on video in some cases, right? That an investigation of the matter is in progress, the scheduling the result of any step in litigation, a request for assistance and obtain evidence and information necessary thereto, a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. In the criminal case, in addition to subparagraphs 1 through 6, the identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in apprehension of that person, the fact, time, and place of the arrest, and the identity of investigating and asserting officers or agencies and the length of the investigation. Notwithstanding paragraph A, a lawyer may make a statement that is reasonable. This is important right here. A lawyer may make a statement that a reasonable lawyer would believe is required to protect the client from the substantial undue prejudice effects of recent publicity not initiated by the lawyer or the lawyer's client. AKA Judge Glanville being kicked off the case. I mean, you could argue this so many ways. A statement made pursuant to this paragraph shall be limited to such information as it is necessary to migrate the recent adverse publicity. No lawyer associated in a firm or government agency with a lawyer subject to paragraph A shall make a statement prohibited by paragraph A. All right, so that is 3.6. We got to look at this video so y'all can see and let me know, because Fondy Willis, the DA, she was making statements while everything was going on with the trial. We'll see if y'all think they were included in that or not. Let me unmute this and then we'll run it. Hold on a second.
Less than 24 hours after filing a motion to dismiss an appeal that could remove her from prosecuting the election interference case against former President Donald Trump and his allies, Fulton County District Attorney Fani Willis spoke about the challenges she faces in her position.
And while she did not address the case directly, Willis did address her critics at a church conference in Marietta. Here's 11 Alive's Karis Belger.
Fulton County District Attorney Fani Willis took the opportunity to talk about judicial equity and take shots at her critics during a speaking engagement at Turner Chapel AME Church. Willis did not talk specifically about the appeal, but she did reference former President Donald Trump and his supporters like Rudolph Giuliani, stating her goal has always been to hold everyone who breaks the law accountable, regardless of their status.
She said, what?
She also used biblical metaphors, specifically citing the Old Testament of the Bible, to explain not only her focus on continuing her work, but the support she's received from those in the religious community, like Bishop Ronald T. Jackson, who introduced her at the event.
What stood out to me is that God will team up a civic leader with a religious leader to fulfill his purpose.
This disgusts me to this day.
Civil servant Nehemiah, he put around him a prayer warrior, Ezra.
Willis is attempting to block the Court of Appeals from hearing arguments to disqualify her from prosecuting former President Trump and his co-defendants. If her appeal is denied, the court could hear arguments in October. I'll have more on her remarks on 11 Alive News at 5.
All right, shout out to 11 Alive. So apparently, Fani Willis could go and talk to a church and have a whole press conference and say something about Trump and Trump supporters, but we can't have interviews with these lawyers, man. They need to get out of here. If what I've seen from Judge Whitaker is true and is going to stand firm in most of these cases, she's not gonna listen to what the state is saying on this one. And they're clearly just don't like what's being said, and like it or not, they have a right. You have a right to free speech. You have a right to speak on this. Even if you go back to Rule 3.6, you have a right. They have a right to talk about their client and what's going on with this trial. And we're watching it before our own eyes as well. So y'all let me know what you think. This was a great response from Yak Gotti, aka Doug Weinstein. But is it going to be enough for Judge Whitaker to say the state needs to go sit down?